Hello. Hi, everyone. Can you hear us?
Hello, good morning, good afternoon, good evening.
I'm so sorry we're late. You guys know I've got Big Amish with me. Hi, Big Amish. Always nice to have you on the stream.
Hi, Wendy. Glad to be here as always. Thank you.
We almost forgot about you guys. I had to tell Big Amish, let's go live because there's so much to discuss. And so, yes, welcome everyone. Um, Misleading evidence, how are you?
Oh,
And
yes.
Kitty,
Hi,
thank you for that
Alicia.
video you sent. We are probably going to have a play on it now. There's quite a lot. As Big Amish is explaining it to me, it is mind blowing because, as I said to him, I've been watching what a lot of channels are saying out there. Of course, we know that mainstream media is running wild with this. So when they don't know what's going to happen, they start to make up a lot of stories, and it's just mind-boggling, right? Like, Amish, I was
Yes.
telling you that people are making up various stories about Ann Taylor, ineffective assistance of counsel. Yeah, I mean, the news is pretty wild with this whole story right now, and so there's a lot. There is a lot. Sister Bluebird is Kelly. Kelly, right? Okay, so yeah.
Okay.
Welcome,
Hi,
Kelly.
Bluebird.
Always nice to see you guys. All right. So uh let's see. Let's start. We're having Big Amish because I think he actually does understand how this is going to happen. But do you want me to bring up that first slide? Let's start with a reading. You know how these lives start a bit slow, and then as we get going,
We warm
it
up.
gets a lot more fun. Yeah, it takes us a while. We takes us a while to warm up. Okay, so I'm going to bring this up. Just tell everyone if you can see this on screen. Try and make it a little bit bigger if possible. Does that work? No, not really. I'm going to just leave it like that, okay? No, it's not working. Okay,
Disappeared. You had it. There
let's
you
leave
go.
it. I had it. Okay.
All right.
So I know people have taken a lot of shots at Bryan Kohberger's writing, but I'm not going to go there because my writing is terrible.
Yeah,
But
so is
Big
mine.
Amish,
But I
I
can
write.
read it because I write like a
Can
doctor as
you read
well.
it? I can't
Yeah,
even read my own handwriting. So if you want to read it, then
that's so
then
funny.
yeah, you can go
So
ahead.
funny. I can't read my that's exactly right. I have the same problem. But but I can read this. His is actually much clearer than mine. But before I read it, I, I
Mhm.
I just want people to understand, and again, this is not legal advice. This is just my commentary, my opinion, and
Mhm.
analysis on what's been filed. But the affidavit is critical, right? And in my last video, I basically said how why the affidavit is important, right? And that is to support the PCR. And because he's filing a pro se, the rules, there's a liberal construction of the rules for Bryan Kohberger. So there's an advantage given to him. And
Mhm.
we'll read the affidavit. And as I'm reading it, I want people to understand what facts under Strickland, if people remember that case, the Strickland case, you have to set out ineffective assistance of counsel, right? But also that you've been prejudiced by it. So you've been harmed. And if everyone
Do you want to
remembers,
just explain a little bit what is pro se for anyone who doesn't
yes,
know, and what is the Strickland, if you don't
thank
mind?
you. I'm sorry. I jump ahead
Okay.
and I got, yes, pro se means that you're representing yourself, that you're not having legal
Mhm.
counsel. Having said that, I did see that Bryan Kohberger did file a request for having a public assistance for an attorney. So he's filed that, but he is pro se, and the affidavit is he filed is considered his supporting declaration for the PCR. So it's exactly what my kind of video kind of addressed, and the power of it. And and don't think I'll address this, but there's a lot of things that go along with it. For example, Judge Hippler and his ability to shut this down. But we'll go into it after we address this. And under Strickland, it's a Supreme Court case that
Mhm.
that allows a Sixth Amendment right as a plea waiver. Right, that's documented. That's set in stone under Garza as well. I'm sorry, and that's another case, Garza, U.S. Supreme Court case. But in order to overcome or to establish an effective
Mhm.
as a counsel, you need to show that counsel was ineffective. Don't forget what Ann Taylor said in the June hearing before Judge Hippler.
Mhm.
If I don't have this additional time with all this data dump, I can't be effective counsel. So that's in the
Yes.
record, right? That's already in the record.
Yes. She said that.
Right? Yes, that's powerful. So when people are saying, well, it doesn't matter what he says, it's not what he says. He is corroborating what Ann
Mhm.
Taylor is saying. That's powerful. Think about it. If Bethany Funk was able to corroborate Dylan Morrison's statements, this is a lot stronger. um,
Thank you, misleading evidence. Appreciated. I hope everybody, if you want to share Big Amish's videos, please do. They're very, very, very informative videos. So, yeah.
thank you, Alicia. It means a lot to me. Thank you very much. I love your channel, by the way. I've been going to.
And Kelly, we're going to play your video as well as soon as we go over this.
Yeah.
But back to what you were saying, yes, she did say that because
So
of the huge data dump, correct?
yes. So when that data dump happened, right? Because it's unindexed, and I want everyone to understand that. And I did a little research on it. So hard drives were given to her. Normally, what happens with the government if you're dealing with a case, for example, it could be any type of case, criminal or civil. If there's a discovery, a transfer, usually they do it on an established software application, not to get far off field, where you share information. They also give you a hard drive that's been verified and produced by a third party. So there's no real shenanigans going on, and it's indexed, and there's search terms embedded into the files. So you could search and use a software application, either one that everyone agrees on or one that is separate of your own, and you basically establish your management system that way. Hopefully, I kind of
Yeah.
addressed how discovery happens in a general sense at this higher level. But we're talking about at federal level. Basically, because of Josh Hurwitz's involvement, this, in all indications, is a massive federal data dump, right? That's how I
Mhm.
would look at it, because Thompson certainly wouldn't have been able to do this on his own, right? We know Josh Hurwitz was the one behind the scenes. He was appointed
Mhm.
special prosecutor at this time.
Yes.
So, okay, now back to that hearing and that data dump where.
Hi, Lucy.
Oh, hey there, Lucy. Good to
Just
see
in
you.
time.
So when that data dump occurs, and she's not given the additional time when they're arguing over that with Hippler. So you have Hippler stating to her, "You asked for the world," something along these lines. "You asked for the world, and now that you got it, you need more time." So, and he denied her, and she brought up the fact that without the additional time and postponing trial, there's no way she could be effective counsel. That's on the record. That's evidence, right? And BK could actually adopt that. And we'll get into the whole evidence thing, but I just want you to know that there's many ways of bringing Ann Taylor's statements about ineffective counsel into the record of the PCR, let alone underlying at the trial stage.
Okay.
So, so BK filed this affidavit, and you have to establish prejudice. That is key to getting ineffective assistance of counsel. And if we all remember, when Ann Taylor filed the motions to suppress, whether it was with the the cast viz, the missing cast data, the IgG, for example, the
Mhm.
motions to suppress and Fourth Amendment, Fifth Amendment, and the Sixth Amendment all being raised for a motion to suppress. It's mostly under the Fourth and Fifth Amendment, but when she was raising that, she brought up that I'm losing my memory now, but during that hearing, um, Lucy might remember, Judge Hippler denied the motion to suppress, stating that you have shown no prejudice, right? And this is where, when Ann Taylor was also going after the raw data behind the federal footprint, right? She was trying to expose the feds. But Judge Hippler said, you have shown no prejudice. Again, prejudice is something for Strickland. I'm just bringing up the fact that Judge Hippler even used the term prejudice. And so that was there. And when we look at this affidavit, we're going to look at some of the words he's using here, and let's point out, if we could find, is there prejudice alleged in the affidavit? So I just want people to hold that in back of their mind as we're reading along on this affidavit. So do you want me to read it, or do you want to read it?
Yeah, before you do, let's just see. Lucy, you said the long game is the push for fusion centers. Well, that's interesting. All of you, if we're not ignoring you in the comments, we're seeing it. So just keep commenting. We'll try and address your questions.
Yep.
Can somebody tell me what is a fusion sensor? Since I'm not in America. Big
Give me 1
Amish,
minute.
what is a fusion center?
Give me 1 minute. I'm just getting it. Hold on one second. Okay. So I'm back. So
Oh, wow. Okay,
Lucy asked
okay,
for
that's
data. Oh,
interesting.
okay.
Data
Yeah. So
center utilization. Okay,
yeah.
so I
So
don't know if you guys watched, there was that lady on Sean Ryan's show. I still want to watch it. Um, she was
yes,
uh,
Lucy's correct. It is. It's data sharing across different agencies,
Islander.
from
Mhm.
federal, state to local, even tribal, for example.
Okay,
Okay, it's just the
okay.
way, like, think that's how they'll share data, but they also create
Ah,
firewall.
okay. Thank you, Lucy. Thank you. Highlander, Highlander.
Yes.
Excuse me if I'm a little bit not so clued up with what's happening over there in America, but that's why I have all of you. I learn from everybody in the chat. All right.
I
All
got
right.
my
Do you want to go
water.
ahead and do you want to go ahead and start reading this, and then we
Yeah,
can go from there.
I feel like I'm back in grammar school. So here we are with the affidavit of facts in support of conviction, post-conviction petition by Bryan Kohberger. It is hereby declared that during a client attorney-client discussions, most of which included all members of Bryan Kohberger's immediate family. I could stop there. Why is that
Yeah,
important? We want to break it down just to
that
say
is
why.
very important.
Okay. Because those are witnesses, right? And he's saying that here are my witnesses for the attorney client discussions
Hmm.
that I'm assuming go awry, obviously, having read this before. But so now you have witnesses already identified not by name, but they're identified. And again, if this was an attorney filing it, the judge would have problems. But because he's pro se, there's a liberal construction or benefit, right? So
Okay.
it's liberally construed in favor of Bryan Kohberger. So if he's saying he has witnesses, there's no way they could dismiss it saying you don't have any witnesses. He says, I do. He's going to have an opportunity to kind of clarify that. And at this stage, the a dismissal, you have to view the facts as alleged by Bryan Kohberger as if they're all true. And if they're all true, does it then lead to um, a plausible PCR claim? That's how you have to look at
Mhm.
it. Okay.
Okay.
At this stage. So, all right. So now he's identified his family members as part of these discussions. So they would be as well as himself, his family members, and Ann Taylor, if not and others possibly, right? There
Okay.
could have been other attorneys on the phone with Ann Taylor, like Miss Massa and uh, Brick,
I
Mark Brick.
think Paolo.
Yes, Brick. Yeah. All right. So we have that down. Now, petitioner was convinced to falsely confess to a capital murder. Okay. So he was convinced to falsely confess. Now, you could take that two ways, but convinced. So whatever was stated convinced him, right?
Hmm.
That convincing is what? What would you call that? Remember the term I used? Prejudice, potentially. Just if it convinced you there's a causal relationship between your advocacy, right, your effectiveness as counsel, and me relying on it. Okay.
Yeah.
So let's continue. So petitioner was convinced to falsely confess to capital murder. This is the plea. And felony burglary. Another one. Two of them. By coercion. So coercion could be what? Let's just think about it. And I don't mean to stop, but coercion could be a couple of things. Coercion could be a threat, right? It
Hmm.
could be how they felt personally to what was being said. It could also be the fact that there is a execution squad ready to shoot him if he's convicted. That's coercion. In my,
Well,
what do
I
you?
did hear that they showed Brian a photo of the firing squad just before.
Wow.
Could be
Okay.
wrong, but that would be coercion, in my opinion.
Right. Well, it raises a reasonable basis, right? That would be coercion in my mind as well. If you're facing a firing squad,
Hmm.
yeah, that's going to make you think a lot differently, right? And you're going to be executed. So certainly, but again, that could also be something that you would consider in taking a plea. But for our purposes, we're looking at what he's saying and taking it as true. Okay. That's the standard right now. This is how a judge would be reviewing this. Okay. After the coercion, he says disinformation. Okay. Doesn't mean false. Disinformation wasn't accurate. What was it? What exactly is it? But he's stating the grounds in terms.
Mm.
And these are kind of buzzwords. They're red flags.
He's not going into too much detail here, I
Mhm.
noticed.
And he doesn't have to. I
No.
believe, let me just, I believe BK, this is a trolling mechanism. This is BK, it's trolling. Um, and if people don't think that Ann Taylor is assisting him or having discussed with him all these things beforehand, you're mistaken. In my opinion, could be wrong, but
Mhm.
it's more likely that Ann Taylor has been involved all along, even though she is not on the record as his attorney. She can provide him um, or answer questions in assisting him in getting the PCR filed. So or other attorneys. Maybe she had somebody else assist, but certainly that's just my opinion. All right, so let me just continue. So we are disinformation, false promises. Okay. Don't know what that is, but false promises. Promise is, if you think about it in contract terms, because that's what a plea agreement is, a contract. So if someone gave false promises that you relied on to then enter into a plea, that invalidates the contract because there's no meeting of the minds. You have to have the meeting of the minds. People have to have the same information, basically, on material terms. That's the key point,
Mhm.
is on material terms to basically execute a valid contract. If there is misinformation, disinformation that affects material terms, you don't have a meeting of the minds, and it allows the agreement to be either modified or invalidated, one of the two, um, in my opinion. Okay, so where are we here? False and the withholding of exculpatory discovery. Wow. Now we don't know who. Okay, so that raises two questions. Did Ann Taylor withhold any discovery information, or is it the state not providing the exculpatory information? Because these are the Brady issues that Ann Taylor raised in the motions to suppress and the motions to compel, saying either give us this or suppress it. And Hitler did neither. He just denied it,
Mhm.
and they didn't get anywhere. So exculpatory discovery, withholding exculpatory
Is
discovery.
he not
That
is he not focusing on the unknown hair that was attached to the bed frame beneath
oh,
Eastern Chapin?
okay. Yes, yes, the hair. The hair.
Mhm.
Okay. So, but when was that discovered? When was that discovered? And so I time wise, I got to know, when was that discovered? Was it pre-plea? Did he have a chance to
Um,
review it?
I'm not sure if he did. I wouldn't be able
Right.
to say. The first we heard of it was in the book review, um,
Right. That's
in
correct.
Broken Key,
Yes.
correct? That was the first we actually heard about it. So
We as
we
the
don't know
public.
when he knew, but I suspect he might have been told.
If it's the hair, now, were they able to test the hair? I don't know. So everything that happens pre-plea, this is how I would look at it. If Ann Taylor had the information prior to the plea and doesn't give it to or let does not inform BK of it, that is an issue, especially if it's exculpatory evidence.
As far as I remember, there was a court filing in June 2025, just a few weeks before, and they said that Ann Taylor included this lab report in the court filing. I'd have to go back and check on it, but
So,
anyway, that's as much as I know.
okay. So then if okay, so if Ann Taylor has that information, did she relay that information to Bryan Kohberger?
Mhm.
And did the other defense experts were involved? Did they have any discussions? I mean, I'm just raising stuff, but just on a purely ineffective assistance of counsel issue, and what he mentioned in his affidavit is, did Ann Taylor, prior to the plea, have information regarding exculpatory discovery that she did not inform Bryan Kohberger about? So
Mhm.
that that's the issue there.
From what I understand, she said that she did relay all of these discoveries to Brian Wright, but his petition is hinged on the claim that she did not. Okay, and that's why um, her defense team released the statement confirming that their expert, Dr. Turby, was hired to actually go and review this crime scene.
Yes, that's right. Turvey, yeah, that's correct. So, but he's what what's happening here is don't forget in my other videos, and we discussed it on your show,
Mm-hmm.
the conflict between experts and defense counsel. This is key because it's not whether Turvey or Ann Taylor's right on whose fault it is, because ultimately it's ineffective counsel. Those
Yes.
issues raise a destruction of the defense team. And how
Mm-hmm.
would Bryan Kohberger rely on it? Ultimately, he's being harmed. His Sixth Amendment right is being harmed of effective counsel. So he's presenting certain facts here, right? He's stating certain buzzwords that we know that legally speaking, in my opinion, raise questions and allow you to bypass the dismissal stage, right? It raises a genuine issue of fact. That's, if you look at it in the light most favorable to BK, having said this, could you simply dismiss this? So far, I don't think you can. We haven't read the rest of it, but based on what he's saying, even though it's some generalities, he's provided witnesses and he's raised certain issues that affect the IAC claim. For sure, he's raising it. Now,
Mm-hmm.
is it enough? That's up to the judge. Is it enough?
Yes.
Right. So, and for all of us, we're looking at it. We'll think, okay, for this initial stage, does it pass legal muster? I think it does, and I'll explain why later. But let's continue reading. So, um, okay. So the exculpatory evidence. Okay, that's what he says about. But keep in mind, the way he's phrased it is during the attorney-client discussions. This is what happened. So we don't know. The
Mm-hmm.
withholding of exculpatory discovery could also be from the state side, right?
Mm-hmm.
And he could provide another affidavit explaining what he meant. So he could do this. And let me just stop here. By him filing this, the state has to respond within 30 days unless they get a court order to extend it. And why do I think that is important? Because at that stage, and this was why I was, I had given my prediction as to a July filing, right? Other than the Wickham book and seeing Cyray, all those were flags for me of what was happening behind the scenes. But by filing on the day he did, now he mailed it on July 22nd. It was entered by the court on July 27th. But let's just
Mm-hmm.
use 30 days from there. The state has to respond. The state has to respond. We'll know who the prosecuting attorney is. Okay. Which I think this is why this is a great smokescreen. This is trolling to me. Is Herwick going to jump into the mix here, or are they going to allow him to lay low? Or is Judge Hippler just simply going to deny it? Those are the questions coming up, but the state has to respond in 30 days. Once the state responds, guess what you have? You have their roadmap of how they're defending this. And obviously, they're going to use Rule 11 plea waiver and saying, well, you signed it. You knew exactly what you were signing. You took under sworn penalty of perjury in your testimony before Judge Hippler and the documents that he checked off and signed, right? That you knew you took a knowing and voluntary and intelligent plea. That's what you did. That's going to be their argument, right? But
Mm-hmm.
we know based on case law that the IAC claim survives that, right? Because it's post-conviction relief. And even though post-conviction relief is very difficult, right? The IAC claim is something that's recognized strongly as a basis for post-conviction relief. And so his basis for it, procedurally speaking, if he's laying out what needs to be in a liberal construction, if those facts are there, it should survive the dismissal stage. So now, and so once the state files in 30 days, keep in mind the clock doesn't expire on amending or supplementing, for that matter, at least amending. You could amend this petition, and an attorney could then jump in, right? I'm just giving you, I'm going ahead a little bit, but I want people to understand you have until, what is it, September 3rd? I apologize. It's either 2nd or 3rd. It's 42, it's a year and 42 days from July 23rd, 2025. So I believe that's September 2nd or 3rd. So you have until that date to amend this PCR.
Okay.
And anything else you want in it. Other claims, when I mean anything else, other claims. But I'm just saying that procedurally so people can understand. Now, going back to the affidavit, so we can look at this and see, does this hold water to pass a dismissal?
Just a quick question. If Hitler denies this extension and holds them to this 30 days, is the state not in trouble?
I'm sorry. If if he just outright denies this
If he
PCR,
denies this extension and holds them to the 30 days, is the state in trouble at that point?
well, no one's filed an extension, but assuming, I think then
Assuming he does. Because
right,
I've
right.
seen people saying that
Yeah.
he might do that.
Well, he could give them extra time just in order to, there's going to be gamesmanship played here. He might say, I'm going to give you extra time, but then you'll know what's going behind the scenes. They don't want any amendments to this PCR. So you're going to see gamesmanship played. So this is the strategy that's, when you're looking at a statute, people are not going to pick up on it, how the sausage is really made in litigation at this level. And
All
at
right.
least that's my opinion. It could very
Okay.
well be, I'll just say this, that BK's affidavit, that's all you're getting. And in this case, this is BK's baby until he gets someone appointed. It could be that. I don't believe it. I believe there's a lot more behind the scenes on this. So,
For
but
sure.
to
All
your
right.
question, did I answer your question? I'm sorry.
Yeah, no, you did. You did. I was just curious about that. Sorry.
Yeah, no.
Lucy
So
says who calls somebody collect? Bryan Kohberger does, guys.
what?
They took his commissary away. What do you think he's gonna do?
Oh, oh, that's right. Is that what they did? They took it away? That's okay. I didn't.
Yeah. I heard that. Anyway, go on.
All
Let's
right.
go on if you want.
Sure. And let's see, the withholding is material to the inception of the plea. Boom. What do we say? Think of a math formula for a contract. The plea is a contract. If A is under the understanding of certain facts, right, that they're considering to enter the plea, and B is believing what is being said on the record. That's where you have these things. Is there a meeting of the minds? That's kind of how you have to think about it. If you take what Bryan Kohberger is saying as true here, what we just read, if you take that as true, does it provide a basis for a PCR to continue? Is it plausible? Has he made out a plausible claim for ineffective assistance of counsel? That's going to be the standard at this stage. I believe under a liberal construction. My Lucy, you're in my thoughts. I can't speak.
She's laughing in the comments. I don't know. You can't take her. She's always like that. You know?
Oh no, I'm not even. I'm not. I'm not. No, I'm
But
just
to
saying.
call
I was
Mike Baker at New York Times collect, well, I think that was pretty smart of him to do that, right?
well. No one's seeing him in person, right? At least no one we know publicly, and where he is a question. But Yeah, he called up the New York Times to get it out there.
I know, right?
So, yeah, of course they would want to cover the story. At least that it's forthcoming. And it's interesting, could have Ann Taylor picked up the phone? Potentially, but she's laying in the background here,
She
right?
has to.
She's laying in the background because remember we talked about those 30 days. In my opinion, Ann Taylor is going to provide an affidavit. I said that many times in the videos as well. Ann Taylor is going to provide an affidavit. Why, you would say? Oh, who's going to admit to being fault? You don't have to say, look, there are attorneys who will provide an affidavit and lie about a lot of things. Don't think attorneys don't lie either. But I have the utmost respect and integrity for Ann Taylor. She doesn't have to lie. She just has to say the truth. And by the way, everything that's being said here in the affidavit is in the record anyway. But Ann Taylor, if Herwick comes forward as the special prosecutor, it's a civil case, but appointed to defend the PCR, this is where the gamesmanship is being played, I believe, because you need someone like Herwick who has the intricate knowledge, just like Hitler has it, right? Having been throughout that whole course of the trial phase of the case, with the exception of Judge, and I forgot the other judge, the lady judge in the beginning. But anyway, but you see the importance of having that type of knowledge. And Ann Taylor's knowledge against Herwick is devastating because she could connect the dots regarding not only the data dump and how it prejudiced her effectiveness as counsel, but also affecting BK's rights. That's how he relied on that to take the plea. That's the prejudice, in my opinion. That's one of them. But when Ann Taylor starts connecting the dots, I'm assuming there's going to be an affidavit, could be wrong, that connecting the dots between Hurwitz's involvement in hiding the federal hand in creating and then hiding the raw data of everything the state built for probable cause and the evidence in this case all stems from raw data that's embedded in a federal agency, the FBI, or through or their contractors, which Ann Taylor never was able to get because of Hitler shutting it down. So you have Hitler actually active in this concealment, in my opinion. So sorry to get a little far afield, but I'm trying to blend in things that are relevant. I hope it makes sense, that are relevant to how BK's petition pro se helps him at this stage. Okay. So going back now. Okay, in the material, the inception of the plea. So are we clear on the inception of the plea? Why he's stating that? He's saying, all of these things happened to me, and I relied on him in entering the plea.
Yeah.
So if any one of those, if he could, by raising it, is it enough factually? He says he has witnesses. Okay, that helps. But this is his affidavit, and he's swearing it as true. So the judge cannot, in my opinion, outright just dismiss it. He has to provide. I believe the rules provided here that you have to provide an opportunity to cure any defects. So now, could Judge Hitler or any judge appointed to this? I'm assuming it's Hitler. Most likely, it should be Hitler. But if Judge Hitler denies it at this stage, where he doesn't have an attorney present, not that he has to have an attorney, because it raises a whole other issue. And I'm sorry to stop here on this one, but he filed a petition seeking public counsel, right, to assist him in the PCR. Now, there's a lot of problems because who has that type of expertise? Being a trial lawyer with a death penalty experience and having PCR experience and appellate experience now, potentially, because you have federal habeas. But that's a separate, but I'm just going down that road a little bit. But so if that's going to take time for Judge Hippler to get a list of qualified attorneys in the state of Idaho that satisfy that. So BK's buying time. He filed it. He's buying time, but he's also putting pressure on Hippler and the state because Hippler would like nothing more than to get this done, get this dismissed. But because BK filed it pro se and under liberal construction of the rules, he gains a benefit. So if BK had an attorney filing these things, and yes, it would have a lot more information. In my opinion, Judge Hippler, and it doesn't mean he won't deny it anyway under pro se, but if Judge Hippler had an attorney, if BK had an attorney representing him filing a PCR at this stage, it is my opinion that Judge Hippler would deny it based on Rule 11, saying you took the plea and he's just going to bootstrap what the state says and adopt it. That's what he did at the trial phase. So I'm sorry to get a little bit far afield.
No, keep going.
Yeah, but I'm trying to tie in stuff as we're reading it, and I apologize if I'm not.
Not at all. We're learning still.
Okay.
It's very interesting to see how this is going to play out, right?
Yeah. Yes, there's so many. It's gamesmanship at a high level.
Do you think they were all part of constructing this when the plea deal was made, even Judge Hippler?
You mean as far as, look, Judge Hippler and Josh Hurwitz, this is not their first rodeo. They know how to conceal stuff and protect that federal footprint because the case would be over. Let me just say this. If Ann Taylor was successful at the trial level, just getting that information, if the judge ruled, right, suppressing that evidence, the case was over anyway. But if the judge says, I'm not going to suppress it, but we're going to get that information from the feds, Josh Hurwitz would have then had to fall on his sword and say, we're going to dismiss the state case. And BK would have walked. However, he most likely has or would have the feds issue a warrant for his arrest and have a federal grand jury indict him if he wasn't indicted already under a sealed indictment. You get what I'm saying? So even if Ann Taylor was successful at the state level, would have that solved the case entirely for BK? I'm not sure. I'm just leaving the possibility that when states are forced to dismiss a case because they're going to expose their relationship and the federal footprint that was so involved in every level of the evidence for probable cause, which is the end of the case.
So what would happen is it would be, are you saying it would be like a federal trap, meaning if that case fell apart on any kind of technicality, right, then the feds would have literally been waiting outside the courtroom doors and arrested him on federal charges?
Yes. That's
maybe
the
like
linchpin. So
like
if you're
crossing
able
state
to,
lines, and then from what I understand, the death penalty would have been on the table again, right? Because his original plea deal only protected him from the Idaho death penalty.
and I think you're right. I think the feds have that's back now.
So let's say, from what I heard before, if he had to find his way into federal courts, then the US government can basically put the death penalty back on the table? Somebody correct me.
Yes, if that, yes, I believe that's come back, and I think if it depends now, it's a procedural, right? And there's a limitation. It's a procedural issue. If there is a sealed indictment back in 2022 against a federal grand jury sealed indictment, okay? If that was the case in 2022 and BK walks, they could then, right, unseal that indictment and basically bring BK before on federal charges in a federal district court. But was the death penalty available in 2022? That's the question, because the sealed indictment took place then. The other argument is that BK, okay, so if that existed in 2022, that's one argument to say the death penalty would apply because it existed, and the sealed indictment existed at that point in time for BK, right? And then they're going to unseal it. So,
As far as I knew, sorry, I don't want to interrupt you. I'm
go
being a
ahead.
bit rude here. As far as I know, the death penalty was available in 2022, but there was something that happened in July 2021 where the Attorney General issued a federal moratorium on executions.
Well, the Biden administration, sure, and that would have stopped it. So if there was a moratorium and you rely on it, I mean, there's numerous arguments to make for BK not to face the death penalty. If there was a moratorium in place in 2022, you could argue it, even though the death penalty was a potential punishment. It was a moratorium, right? And
Is this potentially why they built the firing squad?
I'm sorry, is this the reason why they did what with the firing squad?
They built this firing
Oh,
squad because
well, I think what happened was, so when you're talking about a moratorium, are you talking about the state of Idaho having a moratorium as well? Because the firing squad for
I think
BK,
it was a federal one, and then as far as I know, the firing squad, and just somebody correct me if I am wrong on this, but they built the firing squad for for Bryan Kohberger.
the firing squad, how I remember it, at the state level, was a secondary or third option for capital punishment. Then it transitioned, I think, in 2025, where it became the main. Basically, the governor, I believe that's the case, made it the main, so you could just jump ahead and you go right to firing squad. You don't have to worry about, you know, death by injection or
Yeah.
some other.
Just going a little bit back on my memory there, because I remember when the first, sorry if I'm coughing, guys. Let me pause my microphone for 1 second.
You're looking at it, but the feds do not have. So the feds.
Sorry. Sorry about that. I just had to
No, you
cough
could.
it's like such dry air here. But anyway, just back in the beginning, right? When I first looked at this case and it just came up and I went and I looked at it, the Idaho Department of Corrections spent what I heard, it was about $1 million to put this firing squad at the Idaho Maximum Security Prison. And, you know, they didn't specifically say that it was for Bryan Kohberger. I mean, they didn't say that on paper or anything, but they kind of fast-tracked this whole thing because they were anticipating this high-profile trial to happen. And they basically wanted to know that if Bryan is convicted and he is sentenced to death, that the states, as they said, they didn't want to be humiliated by any inability to carry out the sentence. And the reason I mention that is because if you look at any case where there's an execution, they come with a story of they cannot obtain the correct chemicals needed for, I think it's for the lethal injection,
Okay.
right?
So,
Oh yes, okay, Kelly, you said it as well. So this was their whole stories, that's why they rushed this firing squad, because they said they didn't want to be humiliated, right? Oh, thanks, misleading evidence. Okay, 1.2 million, and they rushed this. Do you remember this Big Amish?
they rushed the. I was reading something about. Yeah, you had raised that before regarding the
Mhm.
drug. You're right that they didn't have the lethal injection formulation. um,
Because there was also something where these pharmaceutical companies actually refused to sell the lethal injection drugs to Idaho. And that's why it
okay.
caused all these execution attempts. So, I mean, they didn't say it was for Bryan Kohberger, but
But it raises the question, right? They're able to,
Mhm.
because they couldn't get the drugs for the lethal injection, or maybe they had something that's not as reliable and therefore it's inhumane and would violate due process. So that's how they
Mhm.
look at it. Believe it or not, even the process of how capital punishment is carried out has to follow due process as well. So, um, and just to push this further, let's assume BK was tried and was convicted, and the waiting on the death row. The governor of Idaho could actually move it forward. He could actually
Really?
declare move him forward and get him executed as quickly as possible.
Wow.
Now there would be challenges for it, but he could certainly move. He could do that. And I don't know if that is something that actually was being discussed. I don't know. That's something you or in the chat, anyone knows about that, please let me know. I'm just raising that because the governor usually is protective of someone's rights, but in this case, I think the best way to to put an end to all the background noise of and the federal involvement and what's really behind this case
Mhm.
is to terminate him, sadly.
Well, we see this a lot.
Yeah. Yes, we do. So,
Okay,
um, I
where are we in this affidavit?
yeah, we went
We always
far
go off
afield.
track. We're like, no, we're not going to go off track, and then we do go off. But anyway, it's all good.
Okay. So it was after the plea. Then he has, it looks like a I.
Wow, Kelly, that's crazy.
It says,
Where were we?
I can't make a consent fully to inform. Could you read that first word? It's after plea. I consent to I
Let me
consent.
read it for you.
Yeah.
Let me read it for you. Can put it up here. Where did we go?
It's after plea. So the
Yeah,
inception of the plea.
there's
Then he has I consent
I
to.
said it says one.
Yeah.
Uh, Counsel's failure to inform
Oh,
petitioner of exculpatory discovery received during plea discussions, namely clumps of unknown hair found in Ethan Chapin's hands, as well as failure of further inquiry.
okay.
So it's a
So
number
that
one, and then it says counsel's failure to inform.
right. So that's what it was. The failure to inform. Okay. So now he's talking. This is Turvey statements about the clump in the hair. That was his uh, at least public statements. I remember, right? That's clear. That's Turvey's statements. Um,
Mhm.
Now, it doesn't mean that Ann Taylor didn't say the same thing. I don't know, but certainly I heard that from Turvey in public. And again, BK could use those public statements and adopt them in his own affidavit saying he's reviewed now these statements. He's reviewed reports regarding the clump of hair, whatever he's relying on. And then he could say, based on that, I adopt that there was hair and, swear under penal of perjury that this is true and correct. So that's how he could just that's if he doesn't have an expert. I'm just saying how he could use his pro se status to benefit himself. Okay, that's if he's not working with anyone, which I don't believe. So okay, you want to continue reading, or do you want me to?
Are you also okay? I can read. I can read the next part if you want.
Sure.
I've got you up on the screen and I've got this right in front of my eyes because I'm as blind as a bat. Okay, and let me try and read it anyway. So it says, petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. Death row was imminent and advised to lie. Petitioner was to gain a legal victory in entering a false plea. Do you want me to read that again?
Sure.
Okay. Petitioner was convinced that actual guilt was not an important factor in considering plea acceptance. Death row was imminent and advised to lie. Petitioner was to gain a legal victory in entering a false plea. That's pretty interesting. A false plea, he says there.
Yes. A false, yes. And you have Whitcomb with a broken plea. So what is
You're right, Kelly. Kelly says this may be proving collusion. Due process was disobeyed, not followed in a laundry list of incidents in the case. Yep.
Yeah, this is all about due process.
Mm-hmm.
and the Hunter standard, but we'll get into that. But let's point out what's going on here in that statement, number 2. So actual guilt. He's saying, look, the false plea, the death penalty and being on death row was imminent, right? That's how he looked at it and was advised. Okay. And I'm going to say, and there's nothing wrong in my opinion. You could have different ways of someone looking at attorney's advice, right?
Mm-hmm.
They could be telling you this is what you got to weigh, and sometimes they'll tell you, "Do you see what they're getting the firing squad ready?" Right? And let's see, a legal victory in entering a false plea. So the legal victory would be what? Is it not facing the death penalty? What is it? But he's providing certain buzzwords. Right?
Mm-hmm. I assume because remember in the beginning he said, Ann Taylor said, her client is looking forward to being exonerated.
Yes.
Do you remember that?
Yes. Yes. But you see the words, let's look at death row was imminent. Imminent, meaning that's pressure, right? That's pressure. So he's saying, I was under pressure that this was going to happen to me. And by doing this, I get a legal victory. I basically bypass what the legal victory is. Is it the fact that he's not getting the death penalty? Or the legal victory is by, I'm actually innocent, even though I'm giving the false plea. And this is where the discussions about the Alford plea come in.
Mm-hmm. Yeah.
Right? There's no doubt in my mind. And I can't help to say this. It seems that anytime information comes out about BK, the G's are involved and provide more information as if, they don't necessarily hurt BK in the legal context. If you think about it, they might say all these other things they want to happen to him, but they provide certain information and background information that always seem to be helpful
Mhm.
in this post conviction analysis. But that's all.
Yeah,
Yeah,
they do. It's
and the
wild.
Alfred plea was one of them. I mean, that stood out like red banana.
Okay. Do you want me to go?
Yes.
Okay. Then what do you want to say about this this part? Why would he use the words a false plea? Is that what he's saying?
Yeah, that's what he
It's
said, entering
false.
a false plea. So he says basically a false plea. Again, it goes to the meeting of the minds.
Okay.
When I took this plea, it wasn't because I did all these things
Mhm.
or I agree with it. I did it because of the legal victory so I wouldn't be executed. Now, at least that's what I'm reading so far here.
I
Right? The
don't think
plea
he wants to be for sure. But okay, do you want me to go read part 3 of it?
Yes, yes.
Let's see if I can read it. Sorry, guys, my eyes don't work so well. Okay. It says a gross misinterpretation,
Misrepresentation. I see it now.
misrepresentation. So he's writing it a bit small here.
Yeah.
Of and what's this word? Promises regarding. Okay, now this is going to be interesting. Just let me just get my wording right here. A gross misrepresentation and promises regarding what a life sentence would immediately
After.
afford petitioner.
Yeah.
Okay, so he's saying, yeah, okay, a gross misrepresentation and promises regarding what a life sentence would immediately afford petitioner. So he's obviously talking about himself. And then he says, and a gross misrepresentation of death row in Idaho, including an elaborate fabricated story of counsel, horrific experience touring an actual 8x8, and then we can go to the next one. Let me just bring it up. 8x8.
Death row cell.
Death row cell, all communicated to petitioner and his family. Let me see this word, what it says here. Authored by IDOC through counsel, thus constituting threats and promises made to induce a plea agreement.
Okay. And there's your prejudice. There's fraud. There's the prejudice. He's laying out the prejudice under Strickland to get that ineffective assistance of counsel claim. So he's meeting a baseline standard, in my opinion, to overcome a dismissal when he's raising this. We might not agree with it, right? Or you could agree with it, doesn't matter. The standard is you have to take what he's saying as true at this stage. And does it provide a claim for ineffective assistance of counsel under Strickland? The answer is, I believe, yes. Right, but go back to the second page. Let's take apart what he said.
Let me
There's a
go to the
lot here.
second page. Let me just go back to the second page. Let me remove that one and add that one.
All right. So why the gross misrepresentation? Why does he?
Yes, Linda, you're right. What was crazy too is the firing squad was planned when there'd not been any trial. So we just spoke about that before because that was a big thing, and they rushed it because of, I mean, they wanted to get rid of him for sure. And then just let me quickly see what Kelly says. Can let BK write this down? I don't think don't they have like a tablet or something like that in Idaho prisons? Why do you think he hand wrote this? We'd love to see a video. I suspect, what do you guys think, Big Amish? Do you think we're going to see a video of him pretty soon?
Uh, well, yes. If there's a hearing set, I don't believe
Mhm.
he's going to be present. I think they're going to do it through a Zoom. That's my gut feeling. That's how I think Hitler's going to approach this. But that's the only time you're going to see him. Either he'll be in court, but my opinion, he's going to do this through Zoom. And you're right; they do have those little pads in the prisons. But
Mhm.
I think for the petitions, it depends on, I guess, the facility. So I don't know
Mhm.
what computer access they actually have to print out stuff. That's a separate issue. You have access to forms, and they give them a pencil or a pen. I think that's probably what they have at that state facility. But
I think also remember, you like Kelly saying, it's unfair to his condition to have him handwrite this.
the,
Well, just before we go on quickly, I was telling Big Amish that I would have loved to show you guys. I bought a subscription to Brewski's membership because I wanted to see what he had to say, the insults. Now, I can't do a live reaction to that because it's a members only video. But if you want, I can actually read it for you guys. I can do that tomorrow. They'd be very interesting. The way they poke fun at him, his family, it's just disgusting. And I think, given that he's in that special housing unit, is this not a possibility, Big Amish, that he doesn't have a tablet or?
well, he's in the protective custody unit,
Mhm.
so it
Sorry,
depends.
protective custody. I misspoke there.
Yeah, but because he have Blue is actually raising an interesting point. If he's if he has a disability, right? If he uses that, if the protective custody unit doesn't allow for those tablets, right? Because of
Mhm.
the type of security. Sometimes that's the case. But if he petitions the warden based on his disability, he probably could get access to that tablet, at least part time.
Okay.
That's how you would go around and gain access to it. If it's denied, you're absolutely right. That would be a due process violation.
Mhm.
So, but yeah, no, that's a very good points, Blue. Great point. But see the standard gross misrepresentation. Why is that stated that way? Do people understand the term what gross means? It doesn't mean like, oh, it was horrible. It made me nauseous. No, that's not what gross means. It's a
Mhm.
recklessness. It's one thing to misrepresent something, right? And say, well, negligently, right? And saying, well, the experience in jail is not that good, right? It's different if you say, wow, did you see what happened? Or I've experienced how bad it is, and I'm just an attorney. I would never want to be there, and I could imagine you being there. That would not fit how your mental state or physical state would endure this 8 by 8 death box, basically. Once you
Mhm.
pass once you start going, it's like storytelling. It's one thing to state the facts, and if you get one wrong, okay, no big deal. Is it a material fact? What is it that it makes it reckless? Gross means reckless, that you were reckless. And the reason you need gross misrepresentation, because it raises it to the level of what would be an intent, right? Negligence is
Mhm.
an intent of just acting unreasonably. Gross is having a reckless disregard for the truth.
Mhm.
Two different standards, and it follows the standard of fraud. So if you have fraud in the inducement of a contract, i.e., the plea agreement, you have structural problems with the plea itself and why it would be vacated. So everything that he's saying here is indicating a structural attack on the plea agreement, not just one of, oh, I didn't mean to take it. No, he's saying structurally, the way everything was presented to me and the coercion in place,
Mhm.
I accepted. I took the the plea. I I entered into a false plea, and I did that because of all these actions, these gross actions, these intentional actions. They weren't by accident, not one. They were all happening at once to pressure me, to coerce me into taking that plea falsely, which I relied upon to my detriment. That's the prejudice, relying on misrepresentations, gross misrepresentations to his detriment. Now he could be attacked on saying, "Well, why did you rely on it?" But once you get into the why did you rely on it, you're already now into an evidentiary hearing. So he's won
Mhm.
in Hippler, and Hippler's not going to want to do that. Do you agree? I mean, that's why we got to understand what the PCR is, where this case is really going. And in my opinion, ultimately, it's going to federal habeas and probably the Supreme Court. But that's where everything changes. Hippler's not going
Mhm.
to let this loose, in my opinion. But if he does, he has to be very careful. Is he going to protect Josh Hurwitz and the feds? Because the IAC claim basically opens up the door to other things. You're going to get discovery. You're going to get all these other things that we talked about before and in my videos as well. So you're going to get that unless Judge Hippler minimizes it, which raises other questions. Like he did during the trial. You're only going to talk about this. But this is where Ann Taylor's brilliance comes in. Her affidavit, in my opinion, is going to be filed and it's going to lay out everything. And guess what else Ann Taylor's probably going to do? And this will be a first breaking on this one. She is
Mhm.
going to dump the 68 terabytes into the court record. So that
Does
switches.
she have does she have access to this?
Well, she has to have it unless someone else has it right now. Because BK can't have it in the prison. They're not going to store it for him. All that, you know, hard drives, data, computers, and physical evidence, let alone software being able to access other things, the video footages. You can't do that in state prison unless they change the rules. But do you see how that could ultimately now backfire and expose everything of Hitler and Josh Hurwitz? Is if she does exactly what I say. And she would have to because she doesn't no longer represent BK and she has to preserve the record for BK and, in my opinion, advance the IAC claim, which she stated in open court. If she provides a declaration saying I was ineffective and provides the basis for it, the the PCR being denied by a reasonable judge is over because you've met the standard. Now you have Judge Hippler, and that poses other questions, and Josh Hurwitz. And if I'm correct in all this stuff, what it's going to do is push the state to say and dismiss the they're going to have to be involved in remedying the violations, constitutional violations. So I could foresee if Ann Taylor does what we're talking about, I could foresee that the state prosecuting attorney who's going to be involved in this case, or state, whatever you want to call it, city attorney in the civil PCR action, they would come to an agreement where they admit that there was evidence withheld, exculpatory evidence violating Brady. Okay.
Mhm.
They could stipulate then if the state says that, and with the IAC claim, but you have both, or at least if the state says that this case is over at the state level, it does not mean that the feds and Josh Hurwitz, or at least then Josh Hurwitz was a federal prosecutor, is now in private practice. But I'm just saying the feds could come back now and charge him.
Mhm.
You see, there's this little cat and mouse game that's being played, but the strategy is very critical as to what is going to happen. And I'm just reading in between the tea leaves the possibilities of what could happen. That's one of the possibilities. The Judge Hippler could also dismiss it and force it down the federal habeas chain, which would mean it's going to take some time, but ultimately it would be overturned. And under Hunter, and I say under Hunter because there have been some critics who would say, well, Hunter v. U.S. it only applies to federal courts. But as I talked to you, Wendy, yesterday,
Yes.
how could something be unconstitutional federally and be constitutional in the state of Idaho? Explain that to me. Is there anybody who could explain that to me? Because the rules, the integrity, or put judicial integrity being in disrepute, that standard as well, the miscarriage of justice, was about judicial integrity. Judge Hippler has an oath to the U.S. Constitution first as a judge. He cannot bypass that. And the officers of the court, he's an officer of the court as well. Attorneys and the judge have a duty to protect the Constitution first. Now, the federal standard is the floor. States could provide more protections to people, to defendants, but they can never give less. So Judge Hippler is in a pickle. He's in a huge pickle. Either he adopts it in his ruling, a miscarriage of justice, right? Or he's going to face the ultimate backhand smack by a federal district court or the Ninth Circuit, which I believe applies there, or the Supreme Court is going to take it up. One of the two, the options are limited for Judge Hippler. He could deny it as much as he wants, but it applies to him. And there's no way around it. Again, I want to emphasize that what I said. That is, what is unconstitutional in a federal court, due process violation we're talking about, cannot be constitutional in a state court of Idaho with Judge Hippler. It cannot, because the U.S. Constitution is the floor. It's the lowest ceiling of protections. A state constitution could add more to it, more protections, but never below that baseline. Okay? And that's why you have PCR relief. You have the state level remedies, right? You're before Judge Hippler, but then there's a added protection. You have the ability to file federal habeas protections. But it's important that the issues are filed at the PCR level, and you have to have these affidavits setting the issues that can only be raised on federal habeas if they were raised below, and that is at the PCR level. That's why you have to have these filings. You have to have
You're
this filing.
saying, you're basically saying there's no real loopholes here, meaning if there's any process that is unconstitutional under federal law, then it's illegal everywhere.
No, what's that? I'm trying to. States do have sovereignty, but they don't have sovereignty to violate the Constitution.
Yeah.
I mean, they have their own Constitution, but they could provide more protections, like I said, but not less. when the Supreme Court in Hunter stated, yes, it was a federal case, and it tied in federal rules, but the rule violation ended up being a due process violation. You could look up Gideon v. Wainwright. It's a great example of how a state rule violates due process and overturned by the SCOTUS Supreme Court. A state rule, and what are the state rules are in play here? The plea waiver, and also to some extent Rule 16, very similar to the Hunter case. It's exactly the same thing, actually. You have a state rule. If Judge Hippler enforces the plea waiver saying, you signed this, you knowingly, willingly violate, you did this, that is a state rule, okay, being enforced by a state judge that violates due process under Hunter v. U.S. There's no doubt about it. At least that's what I'm extrapolating. Again, if there is a violation of due process in a federal court setting, it cannot be constitutional in a state court. It cannot. So I'll leave it with that. I'm not going to belabor the point because that is a floor of protection. You can't just lower the floor if the
Makes
Supreme Court,
sense.
right? Does it make sense?
It makes sense.
Right. So the state sovereignty is regarding their state rules, and they can interpret their state rules as much as they can, except for one thing: when it violates due process. That is the federal charter that they're sworn to protect. Every judge. And that's the distinction. You have federal rules, you have state rules, but when they violate due process of the US Constitution, guess what? They become unconstitutional because of that.
Okay, that makes sense.
Yeah. All right. So the growth, we're looking at back to the affidavit. A gross. All right. We talked about the gross, the promises. Again, he's relying on these statements. It's a reliance. It's a prejudice. I'm relying on these statements or what is being told to me, and they happen to be misrepresentations. Misrepresentation is another nice way of saying fraud, right?
Yes.
Of death row. So he's saying, look, I was about to be put to death. They're telling me all these bad things. It's not like he knows what prison is like. Maybe he does. Maybe he does. But for purposes of this motion, this affidavit, and the standard applicable, it is take what the claimant is presenting as true. And if you do that, and it provides a basis for a plausible claim of PCR relief under ineffective assistance of counsel, the case moves forward at the PCR level. That's all he is. And there's a liberal construction because he's pro se. That is the benefit. The judge has to look at this and provide, I believe that statute provides, 4906 provides that the deficiencies have to be outlined and provide like 20 days or something like that, so they could remedy that. So but could Judge Hippler just outright deny it and violate more rights? Possibly, and maybe he will. He doesn't want this case at all, but I believe it forces the state's hand. I don't think Judge Hippler wants this as a legacy case because it's going to make him look really bad, and he might.
It is.
And he might be before the Supreme Court of the United States saying how he violated the Constitution, the constitutional and the constitutional rights of Bryan Kohberger. That I don't think he wants that.
And Kelly's asking, who decides what happens? Is there an unbiased judge in this case to follow through?
Well, could you raise a conflict because of that? Yes, but I think I'm not sure that actually benefits BK, because what we might assume as an unbiased judge they're all friends. They're all friends in there.
They
Um,
could be.
right. But could you find somebody? I'm sure there is. I'm sure there is. I'm sure there's good judges in the state of Idaho. But I think the rules provide that Judge Hippler, because of all his knowledge and involvement at the trial level, he has all that information and knowledge. So if you try and get a new judge involved, think about how long it took Hippler and going through all these documents and possibly going over 68 terabytes
Jeez,
of
take
data.
forever. And Linda also brings up something pretty interesting here. This is something I've thought about a lot, Linda, as well. We've never seen the investigators asking him questions. This is very strange. Every single case that you look at, you'll always see interrogation videos. Even if a crime was committed last year, any kind of crime, you'll see interrogation. Why have we not seen this? Big Amish, what is your thoughts on that? Why have we never seen the footage of these investigators when they interrogated Brian?
Oh, initially, you're right. And involving, because it involves
Mhm.
feds as well. There was a federal agent or a dual
Mhm.
agent called Joint Task Force Officer. But certainly there was. I'm positive there was. That's why they can't, because I remember early on, one of our first shows together, we talked
Yeah.
about how you have to hide that federal hand, right?
Mhm.
And let the states do it. That's why the trash pull. But once they arrested him, they cannot show the type of questioning because, and we don't know, that should be transparent. That should be out there. You're 100% right, Linda. But why aren't we? That's a great question.
Yeah, Linda brought that up now as well, and it just
That's a
brought
great question.
something to mind as well because it's just wow, how on earth?
Well, and that's a perfect example of what's being hidden, right? Why this all doesn't make sense. That's why this is a due process violation from the get-go on every level of parallel construction. So, yeah, we're never going to see that. BK will be the charges or the plea will be vacated before we ever see that um, video footage. My opinion.
If if we'll ever see it, it should. If if there were no feds involved, Linda, it should be public. Absolutely. There's no reason not to show the interrogation video.
They're going to probably find out that he was a federal agent. He had a top security clearance. But anyway, that's a different story. We'll focus on.
That's a different video.
Um, so, so now we know the benefits of why he's saying gross. There's right. That is important because it wasn't just an accident. Because you could waive little errors, right? You could waive small errors, but when they're intentional and they cause him harm, prejudice. When I say harm, I mean prejudice. He was prejudiced by it. That's what he's outlining here. And if you go, let's see, Mr. The hold on, I'll put my glasses back on. Sorry, incurring. Let's see, including an elaborately uh, blah blah story of consent, horrific yeah, of his jail life. So he's he's being prejudiced. He's being coerced. He's looking at his life in jail, how horrible it would be, right, under these conditions, and he relied on it. He knows that's not the case anymore because he's in there. So now he could tell you about the prejudice. Before he didn't have that unique experience, but now he does. So he could tell you that. Now, if you go to the second page, I saw something that's that's very
Okay,
interesting.
we'll remove this one. Oops. Back. Go to the second page. Okay. Yeah,
Okay,
let's go
so
back to that.
all communicated to petitioner and his family allegedly by IDOC, Idaho Department of Corrections, through counsel, all right, constituting threats and promises to induce a plea agreement. Again, what he relied on to his detriment, his prejudice. But this is what's important. When he mentions IDOC, why is that important? Because he says allegedly by IDOC. Now, this could be
Yes.
also a trolling mechanism. Could it have been IDOC and were the feds on that phone call as well? But IDOC um, records every phone call, or the feds would. So he's raising this very interestingly, right? That's why I'm saying
Mhm.
these are all trolling, in my opinion. He, this is done with another purpose as well. Those recorded phone calls, if were found to be by the FBI, how do you think it affects the case? Because they're gonna have to provide that recording. You see what he did? There is a recording of those conversations over the phone. That's the only way they happen. And if they weren't by phone, let's see. I'm assuming it's by phone, by iDoc, because
Mhm.
that's what it means to me. Because if you're doing it, even if you're doing it in a conference room, I mean a room that the state prison might provide, okay, um, there's going to be people overhearing things. But to me, this is over the phone. I don't think people are flying back and forth just to because having everyone in a room, I think he would state that. And he's being specifically vague on it. Because if there is a recording, a phone recording, and I'm assuming it's by phone, all this is occurring. And if the feds have their fingerprint on it too, this gets exposed. And it is detrimental to the state's um, rebuttal on this PCR. And it also exposed a further involvement of the federal government in this case. So that just jumped out at me when I saw it. So, any questions on it? Does that make sense, or am I far afield?
No, not actually. I mean, it does make sense. It does make sense. Did I say that right? Why can I not talk? Sorry. Sorry.
That's all right. So to me, I believe, based on what he has, he meets the burden. The burden, again, the standard that it's applicable. If you view the facts as true presented by Bryan Kohberger in this affidavit, does it present a claim for ineffective assistance to counsel? I believe it does. You have the standard under Strickland being ineffective assistance to counsel, right? That's in the record as well.
Mm-hmm.
He stated that ineffective, gave examples, what he relied on. He was coerced. What happened? He entered into a false plea because of it. That's the prejudice, right? It's affecting his rights. Prison is not what he anticipated to be based on the representations of counsel. Gross misrepresentation, by the way. So, again, not just an accident, it's something with an intent.
We
So,
did see that last year coming out when he put in those complaints. That's what I mentioned in the chat as well. He put complaints about not receiving his meals, not being allowed to make
yeah,
calls.
that could be punitive. That could be punitive. Who's doing that? So is there prosecutorial misconduct, which is another basis for the PCR relief? But again, I think we just look at the IAC claim. I believe there's going to be, um, you have to wait the chess match, right? You got to see what Hitler's going to do on this. Is he going to say, no, it doesn't meet the standard right now, that even if I take everything you say as true, it doesn't meet a claim for ineffective assistance of counsel under Strickland? He's going to use the miscarriage of justice. I'm sorry. It's a different standard under the state of Idaho Constitution.
Okay.
If he
Linda's
doesn't,
asking you, what is exactly a petitioner in this case, please?
oh, okay, a petitioner. It's just a title used, and because this is a civil proceeding, right?
Mm.
Many times you see people in the United States, they use plaintiff instead of plaintiff. That's a civil case, and you have a defendant, a plaintiff seeking a monetary amount. In this case, a petitioner, the PCR is basically equitable relief. You're asking the judge to do something to modify a contract or vacate it, that being the plea agreement. Petitioner is its term used in equity generally, or when you're seeking like an injunction, which is equity. Um, it just depends on the type of courts. So it's an equitable remedy, and petitioner and respondent are usually used. I don't know here. What is he? Does he use? I didn't even see that if he used petitioner or plaintiff. And the terms really don't matter if you use petitioner or plaintiff. I don't know what he did. Um, could you go back in the first page? Well, it
Yeah,
says the
let's
affiant.
go back to that.
Yeah.
I think it might say that.
Um, let's see. Post commit. It's just affidavit. So if you sign an affidavit, you're considered an affiant. That's the term. So affiant is someone who's sworn testimony of an affidavit. But petitioner is used for PCR relief, and the state would be the respondent. So if I used interchangeably plaintiff or defendant, it's because of the civil context. It's not a criminal context this case falls under. So hopefully,
Do you think this is going to that was really a great explanation. Hi, perfectly broken. How are you? All right. Do you think that this is going to be a very long process?
it could be. My next video is the road to SCOTUS, because ultimately one of two things are going to happen. Either there's going to be enough pressure created at this level, which I laid out earlier, that discovery is going to be dumped into the court records. Ann Taylor is going to provide an affidavit where it's going to be more of a problem to deal with it than it is simply to agree a stipulation that there was Brady violations to vacate the plea, and but that door then opens a
When
secondary.
are you going to put that video out?
It's basically ready. I just wanted to maybe tonight, but tomorrow the latest. Tomorrow midday,
As soon
probably.
as Big Amish is ready, we can go that because there's quite a lot to discuss on this. And so you're going to see I'm
It's a
going to be
long video, by the
a
way.
lot more active. It's fine. I think everybody likes hearing what's going to happen and what you have to say about it. So that's going to be very, very interesting. But thank you so much for that, Big Amish. Before we're not going to make this live too long, guys. So Katie sent us a video. Do you want to go over anything else here, Big Amish?
No, I just think, to me, that IDOC, the fact that he referenced IDOC, because anytime he references something that could be evidence, the judge has to provide a liberal construction and provide him the ability to get that information. This is why it's so, it's such a strategic move. And I want people to understand that pro se litigation happens all the time in PCRs as well, for the very same reason you're seeing it here. But I do believe Bryan Kohberger is a very intelligent person.
I think so. I
Right.
think so
And
for sure.
yeah. And I think he's trolling them because he knows, and so does Ann Taylor. This is trolling material. Now, I could be wrong. I could fall flat on my face. But I think if I pegged the IAC claim before and when it would be filed based on the public interviews of the experts, I think I could get a pretty good read on what's happening here.
It's going to be interesting.
Yeah. Yes.
All right, let's go. Let's go here to that video, and then when you do your video, then we're going to have a look at that. Ooh, what's going on here? Are you guys all with me? Okay. Let's do this. Let's go to this video. I know Kitty sent a video. Sorry. Can you guys hear me still?
Yeah, I could hear you.
Okay, sorry. Some connection problem here again. Wow, okay. So Scotty was actually supposed to join us, and then yeah, I think he's sleeping because he probably did like a 6 to 10 hour live. But okay, just so you guys know, before we play this, Big Amish is going to do another video now on his channel. So as soon as that's up, then we can chat and he can explain what's going on there. But yeah, very interesting. Right, let's do this. Smaller. Okay, Big Amish, you okay to watch this?
Sure.
Okay, let's see a little bit of what they are saying here. We're still trying to
Go ahead. While you do that, I'm just going to grab some more water real quick, but I can listen to it.
Sure. So we're gonna see this. It's not very long. It's going to be interesting. All right. Okay, you guys are still here. Good. Yeah, we'll see what they have to say here.
About Bryan Kohberger, the man who pleaded guilty to murdering 4 University of Idaho students and now wants to take it all back. I'm back with Cy Wright, who at one point in time was a potential expert witness for the defense team should it have gone to trial, a geolocation expert, the chief innovation officer at Vernews. He studied Kohberger's AT&T records. We just talked about the accuracy of them, what the prosecution might have been missing. But now we have something special. Never happened before. I've never done it. I am joined by the father of victim Kaylee Gonsalves, Steve, who I had on the program last night, and Kaylee's sister Olivia, who have questions for Cy. It's great to see you both. Thank you both for taking the time. I'm really just going to hand it off to you, Steve. You, I understand, respect Cy for standing.
Just before we go on, guys, remember in the beginning, hi Lucy, welcome back. Remember in the beginning, these guys had no respect for Cy, and they probably deleted that post. Now suddenly they've got a tremendous amount of respect for him. So
yeah, no, you're right. Oh, before you further it, doesn't his name is Jesse, right, in the top left?
Jesse Weber.
He looks like Eddie Munster.
He looks like
Eddie Munster from the Munsters, the family. Do you ever see that? You're much. Yeah. Lucy might know about the Munsters, but sorry. Go ahead.
no. So they've got a lot of respect. They all look the same though. I'm Cy Ray and this one, and she also. Wow. It feels to me like we're watching actors on a stage. Does anybody else get that feeling? Or is it just me? Wow, I don't know. I just got this weird feeling
feel like that. No, you're right.
Jeez, I don't know.
Wait, was this today or yesterday? When was
this? Just very new. It just came out, and Kelly sent it on a mail. So thanks, Kelly. Just before we did our live.
Okay.
So let's see what they have to say.
By his work, but you say not everybody's doing that. I turn it to you for the question that you might have for Cy.
Yeah, well, Cy Ray came out and stood by his work, stood by what his professional opinion was. He wasn't paid. There's a lot of people who were paid and then turned that into some kind of for-profit, enterprise. And I just wanted to respect somebody who stood by their work because I need more of that. I think a lot of courtrooms need more people to stand by what their expert testimony is. And these gag orders are kind of cloaking devices to keep people from actually being responsible for their so-called expert witness testimony. So there's not a lot of opportunities I get to speak to an expert, to somebody who's actually seen the data that is related to my daughter's death. And I don't take that lightly. And Cy Ray has daughters as well as I do. And I think his heart's in the right place. And I wanted to reach out and find out like these questions that
Wow.
Suddenly, do you want to comment? Do you want to comment on that, please?
You go first. There's plenty to unpack here, but this is interesting, and I'll tell you why.
No, go for it. Go for it.
Okay, first, the fact that Steve G is now talking directly to Cy Ray. I'm assuming Cy Ray has access to BK. So this is basically a plea bargaining again. This is what it seems like to me. Steve G is giving statements to Cy Ray, but it's really meant for BK. Now, having said that, Steve G saying that that he's willing, that Cy Ray's giving his expert opinion and standing by it. Well, Cy Ray said that Nick Balance has concealed 90% of the CASVIS data, the cell tower records, right?
Yes.
So, and there was a gag order there. So this is very interesting. The dynamics here are very, very interesting, to say the least. Because Cy Ray, in my opinion, wouldn't be in this, as an expert, you just don't now put yourself into the mix, all right, unless it's consented by BK. That's just my opinion.
When you say consented by BK,
right, meaning, so for him to talk about the case, right, and I don't know what he's going to say, but whatever he's going to say, for him to even talk about the case, did he get consent from Bryan Kohberger? Because whatever you say could affect your rights potentially. Or
okay, let's hear what he has to say. Sorry, just tell me when to stop.
Yeah, no, go ahead.
I have that even the defense and the prosecutor, nobody wants to help me with. So if he's willing to tell me, hey, how can you have cell tower dumps, the whole tower dump, and then his phone turns on at 4:48? How is that not? How do we not have timing records in there? How do we not have that? That's my main question for him.
Cy?
Wow.
Yeah, and I think there's a couple things to look at with that question. Number one, when his phone turns back on, there's no doubt the route that he took. There is no doubt the connections to the towers. I've been very concerned from the get-go of why we're not seeing that data. The map that's on the screen right now is a perfect example. That was a map that was used in all of the search warrants. Essentially, you will find that map right there repeating throughout every search warrant. It's wrong. And it's wrong in a number of disturbing ways. And when you actually take the data that's out there and you map it, I can tell you, Steve, there's no doubt where that device is when it turns back on. And it's not Thorny Creek Road. It's south of there. It's still on 95. It's still southbound. It does eventually pull off and it travels east and then west, and then kind of back up to the north to come back into WSU. But we're talking 25-meter radius GPS pings, and they perfectly align with the roadway. When you measure the distances between them, the speeds are 100% appropriate. You can see the vehicle come to like a three-way intersection and it turns left, and the next one it turns right. It is turn by turn. There's absolutely no doubt. I've been saying from day one, they need to map all the data. They need to go get the data. They need to map the data. And I reserve the right to change my opinion until all of that data is put forth.
Wow.
I think it tells a story. And I don't know how an expert prompts both the investigative side and the defense side of, hey.
What?
So he said until he gets the remaining data, right? I forgot how he phrased it, but which he never got.
Wow. Okay. Hang on.
Yeah. So that's just shot. I mean, he's saying, how could you finish? He reserves the right to change his opinion until he gets the rest of that data, which raises a question again.
He said there he reserves the right to change his mind, but did he not say in the beginning that the routes and the phone pings didn't align? Somebody correct me. Because that's how I understood what he said.
Yeah, you might have to. Now I'm confused as well because he said what I think he said was the map that was used by the
Uh-huh.
by the prosecution was not accurate. That when you put
Okay.
the data that he has between the car and the phone, that it showed it's actually what south of the highway he mentioned.
Mhm.
So this kind of a map that we're seeing was not accurate, and then he reserves the right to obviously when he gets the data to change it. That's my understanding. But anyone else?
How can he
I know.
change his mind if he doesn't have it all?
Well,
That's-
but that's the question, right? That's also the parallel construction. That's something that in the affidavit, the exculpatory data, the discovery. So he's raising it again indirectly, and he's actually, I can't wait to see the rest of it. What else does he say? But he's giving
See
his
what he
opinion again.
says.
He's giving an expert opinion that now BK could use in an affidavit potentially of his own, not even Cy-Ray. It would be
Oh,
great to get Cy-Ray's, but
let's see what he says here.
These are bottom line basic steps that need to be taken. If that was done, what would be found is the very next day, he mirrors that exact same route. He starts off in Pullman, he comes into Moscow, he drives down 95, he pulls onto the dirt road. He's in the exact same area that he drove the night before after immediately committing these crimes. And after he goes to that area, he drives straight to the Snake River just after dusk, getting into the darkness about 8:30, 9 o'clock at night. And why would somebody be driving to the Snake River on that?
wow. So for him to say commit, that's where you know he's on both sides of the fence on this one. But for him to say that, he doesn't have to say that. That's just his opinion, right? He cannot say that he committed the crimes. That could be his opinion, but not as an expert. So why would he say that? Is he going to be used as a witness? If the PCR goes forward, he's going to be used as a witness, and it helps both sides. But don't forget, the ultimate issue in the PCR is to vacate the plea. So it doesn't matter what he says negatively about BK, as long as it gets the plea vacated. That is the goal. So for him to have a bias raises a whole other question as well. It goes to, did BK rely on him? And maybe BK didn't know that he felt he was guilty, because BK's position is that he's innocent. So now you have an expert on his team who thinks he's guilty. That is due process violation as well. Because if he took the stand and if the prosecution asked him to answer that question and he does, that's one of the most prejudicial statements an expert could ever say. Oh, the phone data is all wrong, and there's a lot of errors with Mr. Balance, the concealing all this information, but he's guilty. You could see how that works out.
I was actually just looking here where I put his original affidavits. If anybody remembers that, but I'm not gonna go to that right now. See if we if we see it.
But that was not a negligent statement that he made. That was intentional for him to say that. Now, whether BK knows about it and approves it is a whole different issue, right? But again, my point is, I'm looking at this structurally. What does that do to the plea agreement? His bias would affect someone from taking a plea. Because if you think your expert, and maybe there were other ones, but if your expert now believes you're guilty, is he going to be an advocate for me, a zealous advocate? It's an attorney term, but. And if not, if he thinks I'm guilty, is that going to impact his testimony at trial? Certainly that's a concern. So he's raising a whole other issue now, and it's broadening it to what we initially said in my first video, and that's strictly
I
true.
actually have it in front of me here because I did do a video. He says in his affidavits, I'm going to just read it for you. I'm not going to send it onto the file before we watch. He says, in my nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and defense. It rises to a level beyond simple miscommunication. Back there, because I was doing something. Sorry. What did I do here? Sorry, let me just go back to it. Or oversight, and is clear and intentional misrepresentation in the hope to conceal a much larger issue. I respectfully request the court gives this affidavit the due attention it deserves and explore these issues further. Signed on the 25th day of March, 2025. Okay, his words. That's his words.
Yeah, he said not only the errors, he's saying there's hidden, the feds have this information. I think it goes on to state, but, and even Ann Taylor, she just wanted to ask certain questions to balance, which would have identified him as the source and or the source of missing information and the source of the information provided to, I think it was Detective.
Hi, Dick. I love this username, Kiss Me Where I Pee. How are you? Okay, I'm just read over his affidavit, but he says here, he says that it rises to a level beyond simple miscommunication or oversight and is clear and intentional misrepresentation in the hopes to conceal a much larger issue. What does he mean when he says that?
That's the parallel construction that the feds had identified. It has the fingerprints of the Fed all over the place. And it started way before the state had probable cause.
All right. Okay. So those were his words. But let's carry on watching here quickly.
Path. It's concerning to me because we also see some activity that is indicative, in my opinion, of him looking at his navigation, specifically using his phone to get into a perfect area. The other thing is pattern of life. We got 6 months worth of records on Mr. Kohberger. It's very easy for us to see what his normal pattern looks like. This is a complete deviation from that normal pattern, and it stands out. It tells a story.
That's very compelling to hear. And look, it highlights what an overarching theme has been criticism of prosecutors in this case. Olivia, I want to throw it to you. I understand you have questions as well.
Yeah, absolutely. So the questions I came prepared for kind of moot compared to this one. So you're speaking of GPS data, which I'll be honest, I really wasn't aware of. So when you speak turn by turn, is it fair to assume that that data, you mentioned it went back 6 months, was used for the cast report, which did put the defendant at my sister's home on 23 previous occasions? Because I know a lot of pushback that happens is when it comes to this cell tower, they say there's only 2 in Moscow. It only narrows it down 10 miles. Can you kind of help to dispel some of the specificity that can happen with GPS data that was on his device?
Yeah, and I need to break that into 2 pieces. Number one, the 23 prior visits based on that cast report is 100% inaccurate. It would never hold up in court. Any expert in this field who reviewed that report would be able to show you incredible flaws. The problem, too, is it isn't just 1 or 2. All 23 of those that are reported in the cast report are wrong. They're inaccurate. The times are off. It's just a really bad analysis. With that said, if the agency and the investigators actually dug into the records they have, not only is there evidence of Bryan Kohberger being in the area of that house, there's evidence of him being on the property. There's things that they could follow up on to confirm this. And in my report, and luckily it's just been released, I actually outlined follow-up that would be reasonable to assume an investigator would do to confirm the prior visits to the house, which I think are very critical. Pattern of life is everything in this case. Seeing the planning phase and then leading up to the actual murders themselves, us being able to piece that back together and tell a comprehensive story that makes sense that's the job of the investigators. So I can tell you that I feel very comfortable that Bryan Kohberger was in the general area of the house several times leading up to the murder.
Leading up to, big difference.
Leading up to, general area and leading up to.
Yeah, that's reasonable doubt anytime, in my opinion. But again, I think this is important to see how, and I'm not saying, is this a planned kind of thing, but I cannot imagine Cy coming out now after a PCR is being filed and stating this, what I've seen so far. And he stated that in the interview with the custody queens, I guess. But what it does, think about what the IAC claim. BK is also going to potentially use this and add another affidavit. Cy Ray's going to be added in the mix. Ann Taylor's going to say, I got Cy Ray as an expert. BK approved it. Obviously, he has to prove everything. I guess prove experts. I'm not sure he does or doesn't, because it's not. But I believe he does. But and at the time, think about it. Because if there's no way an attorney is going to retain, or a client's going to retain an expert who believes you're guilty, right? So I don't think that ever came out. It's coming out now after post-conviction, which again shows the prejudice that BK needs to show regarding ineffective assistance of counsel. He's going to argue that Ann Taylor relied on him too, or that she knew about his bias towards BK. Either scenario violates BK's Sixth Amendment rights. You see, now Cy Ray is going to be added to the mix. In my opinion, could be wrong. Maybe they don't need it. But these are all flags. Somehow this is going to come forward. Why he's coming out now? Again, red flag.
Crazy. I think he's part of the whole story. Him, Turvey, Whitcomb.
Yeah.
All of them.
I think he came by the house the next morning. I think he came by the house the day after that. So there's more than enough evidence to show that. There are databases and ways that if the right people use the right legal process to exploit today, the data's still there. There is some really good information that could come out that I believe would show the device actually at or inside the house, opposed to just near it.
Steve, this is an important conversation based on what we talked about last night. I'll say it again. I'll say it one more time. I think the likelihood that he gets a new trial is very, 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 very low. But if this is now a conversation about a potential new trial, do you want Cy to be part of this push for investigators, for law enforcement, for prosecutors to essentially, if I'm understanding this all correctly, be more thorough?
It's almost bigger than that. Technology is moving so fast. It's radically fast. And I'm an IT guy and I can barely keep up. These courtrooms, when they were talking about a JSON file, I just wanted to jump up in front of the judge and say, this is ridiculous. There's no expert in the room right now. So I think what we need to do is embrace technology more. And we need to have experts that are actually driven just based off of technology. And things have to change. I mean, the courtroom, I'm watching somebody typing when the whole thing's being recorded. They resist change. They don't want change. We have to embrace change. And that's how we get justice, is we start embracing, this technology. And that's what I'm trying to say is this case.
They were against technology.
Yeah, and now they're all for it, because don't forget,
he's being like a little baby bitch. Sorry.
Yeah, no, your technology is used by the feds and they do it cryptically, because by the time they're caught, then they modify their policies and procedures. But until that time, they use that technology to violate your rights. Now,
that's exactly what they're doing.
Yeah. I just wanted to point out again, Cy Ray's testimony and what Steve G's basically acknowledging is that there was a due process violation in how the feds, the state for that matter, had their cast evidence was faulty, right? So that it's a due process violation, because if that would have been admitted at trial, think about how prejudicial that would be. But that's why this is all a due process violation and Brady violation as well, especially if it's exculpatory. But even if we're assuming it's not exculpatory, the fact that it was not provided and all these errors inherent in that cell tower record dump, or as Cyril is pointing out, that is a due process violation. That doesn't come in.
Bring it on. The evidence is there. I'm not scared of it. I actually think there's so much undiscovered evidence that this case is actually should have been case law.
Gary says it.
Yeah. I'm sorry. It's just every time he says something that helps Bryan Kohberger's case, he's now saying, let's see the evidence. And what we just talked about before, I said, is Ann Taylor going to dump all the records into the courthouse? So, I mean, this is Steve G to say, oh, I want all the evidence out there. Wow. Okay.
Should have been case law. And it's unfortunate that we didn't get there. And I'm trying to save another family from dealing with the same headache that we just went through. And we're talking about life and death, and it's that important.
I mean, Cy said it before. Two things could be true at once. Bryan Kohberger could be guilty, but there could be faulty parts of the investigation.
Exactly.
Olivia, you said you had other questions that you felt are moot. What are those other questions that you had, or anything that you want to address for Cy?
Yeah, so a lot of my questions were just about kind of the analysis and how specific we can get, data. I have my phone right here. Obviously, it's connected to Wi-Fi, but let's say it wasn't. Could you know that I was right here just with cell tower data? Or would it require an additional piece like a timing advance record?
It would definitely require something additional than just cell tower connections. And I think the question you're asking is really pivotal, and it mirrors exactly what Steve is bringing out. You have to ask for it. You have to know what to ask for. You have to know the proper legal process to obtain it. And then the most important thing here is you have to be able to analyze it. You have to be able to properly analyze it. And I don't want to get too far into the weeds of some of the knowledge that I'm talking about tonight, because some of this hasn't been released, but I feel very comfortable stating there is no work product in this case that took the 4 victims' phones, 6 months worth of records, which they have, it's in evidence, took Bryan Kohberger's 6 months worth of records and sat down and did a deep dive analysis of seeing where those devices intersect and when they collide. And I feel very comfortable in this next statement that if somebody did that on the prosecution investigative side, it's not a mystery of where some of these connections happened. It's not a mystery of what I'm going to say, at least the pre-planning phase of this crime. There's some very telling evidence.
How is he talking about the pre-planning phase?
Yeah, because I think, okay, he's opening up a whole other door, and Steve G admitting that there's evidence they haven't seen. All this, Cyril now is, it depends how you want to take it. He's either being a prophet here, telling us what this is all going to show or it has shown, right? Or is he raising it because if you go down this path, are you going to find out that BK was a federal agent that they can't really discuss and had top security clearance and was involved with the Joint Task Force or and the like, and that this was a federal operation? I don't know. I'm just suggesting that because everything that he says is not accidental. It's intentional. So what is the intent? Is it to bury BK on one hand, or is it really about getting BK out of that plea and getting the state to basically, vacate that plea by admitting that the that the evidence that they have not provided the rest of the evidence or a due process violation, as he's pointing out. Sorry, I was hiccuping it. Does that make sense? Kind of.
It does. Thank you, guys. Sorry, I'm also asking questions, so we're learning a lot from Big Amish here as to how this is playing out potentially. So yeah, sorry for.
But
for
I
the
believe
question.
now, I just want to say, I believe Steve G was somehow involved in this case, a lot more than I ever thought
Mhm.
before. But
Yes.
that's just my speculation. Again, I'm just looking at this and saying, how does Cy Ray and Steve G get on the same screen and basically help BK? And that's what they've done, in my opinion. They've said other things, but they've also said things to help him.
Wow, these people freak me out. Let's see what they say here.
In those phone records that, to your point, we can be a little bit more specific. We can be a little bit more isolated instead of just saying, well, both phones are in Moscow. Yeah, no, they're actually both on the same street corner. Or more importantly, there's a couple phones that belong in Moscow that are in Pullman at times. And there's an intersection and a collision between Kohberger and a couple of the victims in Pullman. So the evidence is there. It just needs to be properly analyzed.
Cy, I just got to jump in 1 second as I'm listening to you speak, and I'm listening to your expertise in this and thinking that you were retained by the defense at one point. You are quite knowledgeable. You are the kind of expert that any side would want. Did you, in your experience, the reason I say that is because Bryan Kohberger is saying he had bad lawyers. He had ineffective assistance of counsel. That's what he's claiming right now. I'm thinking all I've ever heard is that he had good attorneys. And if they were considering you, I feel like that's a good attorney. From your perspective, do you think that he had incompetent, ineffective counsel from your experiences on that side?
Here we go.
Boy, that's a loaded question.
It sure is, but I'm asking it. And he had bad lawyers.
This is a
He
great
had
question.
ineffective assistance of counsel. That's what he's claiming right now. I'm thinking all I've ever heard is that he had good attorneys. And if they were considering you, I feel like that's a good attorney. From your perspective, do you think that he had incompetent, ineffective counsel from your experiences on that side?
Boy, that's a loaded question.
It sure is, but I'm asking it.
You see that pause? Did you see his face? Oh, wow.
Look at Steve G and look at Olivia, like they're like,
Look there.
oh my
I
God.
mean, oh, wow. Look at that. That was like a perfect stop. I mean, he paused there.
Perfect stop. This is like entertainment. This is like a real show. That's
Oh, let me just go back. I want you to see his face. He pauses. He
Yeah.
doesn't know what to say. Okay, hold on. Let's go back. Sorry, guys.
Mo put Parmalat on his toasted sandwiches. Everyone wanted one. Mo cheese, please.
Attorney, from your perspective.
I want you to see this. Give me 1 second. My husband's messaging me. He asked, "Do you want tea, my love?" And I'm like, "Yeah, I do want some tea." And then I've got two different teas or 3. And he's like, "Do you want tea, rooibos tea, sugar tea, chai tea?" Just any tea, please. I'm watching Sarah. Sorry, guys.
That's all right.
Okay.
Some good tea.
Tea, so well, I'm gonna get a tea surprise, but I want to see what this guy's face. Watch his face.
Yes.
Do you think that he had incompetent, ineffective counsel from your experiences on that
That's
side?
him.
Oh,
Boy, that's a loaded question.
It sure is, but I'm asking it.
Oh, wow.
I think that there's plenty of
know.
ineffectiveness to go around on the
Okay.
defense side, prosecution side, and quite
Did you
honestly,
see
and
that?
he agreed.
Did you see their faces?
Wait, and
God.
Steve G agreed. This is exactly what BK needs, to be honest with you. to
They
vacate
can't
the
even hide. They cannot even hide the look on their faces as he asks them. Sorry, I got to see this again.
But
I hate
just
doing
before
this.
yeah, go ahead.
Wow. Go on. No. Say.
He
Sorry.
said there's ineffectiveness to go all around, meaning himself, Turvey, and Taylor, the whole defense, by that statement. That is very powerful for BK. Very powerful for a PCR. But it also opens up the door to resolve the case without all this getting exposed. This is getting exposed. What it's telling me inside baseball is that you, the state of Idaho, and the feds resolve this case right now, or we're going to open up Pandora's box, and it's not going to look good for a lot of people. This is going to get bigger and bigger than you even realize. You know, is the squeeze worth the juice? That's what he's saying. They're all saying it. Steve G saying it, and Cy-Ray. Steve G's giving enough information to help BK as well, with, you know, evidence that we've not seen that I'm sure is going to be, I forgot how he phrased it, but, you know, let it all out there. All of this stuff. And Cy-Ray just saying what he just said now to me is telling me there's going to be an attempt between.
Thank you, my love. My husband came with my tea. Which tea did you bring?
Tea.
Everybody in the chat wants tea.
Yeah. Yes, please. That would be great. So either this case gets resolved by a stipulation, by an agreement in which the state agrees that they violated BK's rights, at least on Brady material. They can make up whatever they want just to hide what's really behind this case, which is something that we should be looking at as well. But or if it doesn't resolve itself here, this is the case that goes through the eventually through the federal court system, and Hunter is going to be the saving grace and the dynamite against Judge Hippler. But go ahead. I'm sorry.
No. Thank you for this, Kelly. This was just a few hours before we went on, so what a surprise. I love
great.
when everybody in the comments sends us stuff, because, you know, we watch, but this is coming up on my feed all the time. But you know, you guys are right. They all have a creep factor, but I was so surprised by their faces, because they all know something. You know, when you read people and you look at them and you're like, oh wow, no, this is just strange. And I want you to look at all four of them.
Sure is, but I'm asking it.
I think that there's plenty of ineffectiveness to go around on the defense side, prosecution side, and quite honestly, and you know, I won't be very popular for saying this, on the judge side, I think there's critical errors that were made throughout this entire case, where it's just this giant snowball that kept picking up speed as it went.
Wow.
You know, one of the biggest things, and just to be clear, I got involved in this case because I did a peer review. The actual expert on the case ran into a problem, didn't know what to do, called me. I looked at it, I thought I'd be.
Okay.
Interesting.
Go for it.
And the judge. So he's, you know, we heard that before in his other interview, but he's saying Judge Hippler's rulings affected Ann Taylor and ultimately BK's Sixth Amendment right, and to the plea. So, I mean, it also raises an issue of conflict. So Cy-Ray saying, look, these rulings. Now you could argue whether, you know, was it just negligence again, or were they intentional? Raises a whole other issue, because judges make mistakes all the time, you know. But was this to conceal that federal footprint? I say yes. And Josh Hurwitz certainly switching coming from the Fed to the state side with all his knowledge and influence. Can't say no doubt, but beyond a reasonable doubt, if we use that standard, that's what he influenced the judge with. Because there was something bigger here, much, much bigger. And they needed a second.
And they keep saying it. They keep using the word sacrifice and a much larger issue.
Yeah, I agree.
They're basically telling us.
Next thing I know, I kind of got sucked into this thing. Yeah. So it was never my intent to be involved in this case. And I'll say it time and time again. I told the defense probably at least 100 times. The best thing that happened for Bryan Kohberger is that we were never contacted to help provide assistance on this case. That's my job. Across the country, every day, across the world. If I feel very comfortable in saying, if myself or some other experts in this field around the United States were contacted early and brought into this investigation, we would not be having this conversation tonight.
Well, let me tell you something. Oh,
I don't want to interrupt.
No, please.
But that's not the first time I've heard that. I've heard other experts say the exact thing to me. Said, Steve, you reached out to me. I'm here. I'm an expert, and they won't talk to me. So let me that lit a fire. That lit a fire as me as a father that I'm doing.
Sorry about that.
I almost have to hear that again. What he's saying that he wouldn't have helped if Cy Ray, if we just go back to that statement that he said, is it because he feels? Go ahead. Let me just hear that one more time.
Okay, no problem.
That I don't want to interrupt.
No, please.
But that's not the first time I've heard that. I've heard other experts say the exact thing to me. Said, Steve, you reached out to me. I'm here
100 times. The best thing that happened for Bryan Kohberger is that we were never contacted to help provide assistance on this case. That's my job. Across the country, every day, across the world. If I feel very comfortable in saying, if myself or some other experts in this field around the United States were contacted early and brought into this investigation, we would not be having this conversation.
Well, let me tell you something.
I don't want to interrupt.
No, please.
But that's not the first time I've heard that. I've heard other experts say the exact thing to me. Said, Steve, you reached out to me. I'm here. I'm an expert, and they won't talk to me. So let me that lit a fire. That lit a fire as me as a father that I'm doing things like I'm doing.
So there's two things to take away. One is he saying the errors involved with the FBI cast and balance and the hidden information, the raw data. That's one. The other thing is that he believes BK is guilty. So two things. Again, it's a Sixth Amendment violation. He says they wouldn't be involved. You see that? Because he's already saying, I already assigned guilt to him. And so how could you be an advocate for somebody you believe is guilty? It's an oxymoron again. Potentially it could happen, but only if you deal with the procedural issues, the substantive issues of the raw data not being provided and the errors of the FBI. Yes, that narrow scope. But he's already telling you he had a biased view. And that only came out after the fact. I doubt BK knew that before. Before he took the plea, I doubt BK, I could almost be 99.9% certain he didn't know that.
It's doubted.
Yeah. So now it comes out, it helps BK again to vacate the plea because now you're finding out that one of your experts who provided reports actually had a bias against you. So how could he provide an opinion, an expert opinion that's unbiased?
It almost seems like this is planned this way. It's just too obvious. It's too obvious.
Yeah. Yeah. It's something, there's certainly an involvement with this, just seeing these four individuals together is a problem.
Yes, they seem, I don't know if anybody else, though initially I said they look like actors, but now that you mention it, they seem very comfortable with each other, right?
Yes, they do. They do. Yes. As if, yeah, they do. There's no doubt about that.
There's a level of comfort that's, we're not just meeting for the first time.
Did they spend time together before this show? Like the custody queens, 3 hours of prepping, which, by the way, they did ask good questions, but 3 hours of prepping provides a baseline and to expect certain questions. Is that the same thing that we're
they weren't, if you watched them, they weren't as comfortable with Cy Ray as what these two are.
Yeah.
They almost seemed, well, I could tell Ron, who was on their show, and I didn't watch the whole video except what we reacted to, but Ron seemed extremely uncomfortable with him.
Did they ever show the 3 hours before?
No, but look, they asked very good questions, so I'm not going to diss them in any way. But
no, not at all.
I think they did ask very good questions, but he seemed to evade their questions a lot, and you could see that So Ron is on their channel, and I could tell as this was happening that he was becoming a little bit irritated because every time he asked Sarai something, he would kind of sidestep and avoid the question.
Yeah, I remember. Yeah, and that's why I was just curious because the 3 hours before,
Okay, Patty Ann thought the same thing. He just seemed extremely uncomfortable compared to what we're seeing here with these four.
Yes, that I could agree with.
Doing right now.
And by the way, Steve, for anybody who doesn't know, you were the guys who orchestrated this. You said this is an important conversation to have. We want to talk to Sarai about this. I'm so glad that we did, particularly now. We didn't know that Kohberger was going to file this yesterday. So all of this happened at once. Sarai, thank you for taking the time to answer these questions and explain it. Steve and Olivia, I said this to Steve last night. I've been thinking about you guys this whole week, and I'm going to be, you have an open platform here to always talk about what you want to talk about with this case. So thank you all so much for taking the time to, again, have a really important conversation.
Thank you for watching. Subscribe below and download our News Nation app right now on your phone, and you will get fact-based.
That was great on two fronts, entertaining-wise and also legally. This is.
Oh wait, if you guys want to do one tomorrow, I watched the Nancy one last night. Oh wow, that is great. I don't want to watch Nancy, but it's like watching a car accident. You don't want to see it, but you also can't look away. And
Nancy Grace. If you want, I've not seen it.
That's going to be a good analysis for you to look at. So what I can do is I can also send it to you, so you can look at what she's saying and what her experts are saying on
that would be
her
great.
channel.
Yeah, send me that link, and that would be perfect to go.
I will definitely do that. But I think this was interesting. So thank you so much. Thank you, Kitty. I appreciate it. But they do seem comfortable. You guys are going to see. So she's going to ask a few questions on that video. I think I actually would love Big Amish to react to those questions from Nancy Grace and from her all-star panel.
I could expect a very demonic feeling. Oh man, it's just how she approaches things. But this will be interesting.
You should have been on Skull. I was watching this morning, and what did he say with? Oh no, it was somebody else. He said, "I rebuke you, Satan."
Yes, that's great. That is a great. The Archons, yes. Bluebird. But yeah, I rebuke you, say that's a great. The power of
Patty, and I think if Big Amish is free tomorrow, then we could do it a little bit earlier, even depending on his time schedule, and let's work it out how we want to do it. But I want to send it to you because that woman, I don't know. I mean, I don't even know why this woman, but we'll talk about that tomorrow. She has guests on, and then, well, I shouldn't do too much in this one because I see with this case, she chooses guests that agree with her, but normally on her videos, she will shout at her guests and say, put him up, or cut his mic. And I'm, wow, Nancy, why so rude? Oh, did he play it, Lucy? I didn't see that. I just saw him doing something. I know I watched the part where he was playing the consoles at CrimeCon, and yeah, that's when he was saying, "I rebuke you, Satan."
I'll bring my crucifix for the show.
Don't worry, I've got a bottle of holy water here. I'll take a sip every now and again.
I just keep thinking of her.
Why are you laughing?
I just keep thinking of her because she gives me the creeps. It just does. but she just gives you the creep all the time. And I'm not saying, I think maybe she does it because I think it works for her, right? I guess that's
It's all theatrical because any normal person who went on her show, if you came here and I'm telling you to shut up or something, you're gonna disappear and just go off the stream.
yes. Yeah, the last time I watched her show was with when she dealt with John Bonet and John Ramsey again.
Oh,
I think,
yes.
yeah.
Guys, we need to cover that case.
Yeah. And Miss Woods. I mean, again, we talk about DNA analysts messing around with evidence or having the ability to conceal suspects, right? There's a lot of things you take out from that, but yeah, that would be great as well. But that always disturbed me in that case with her.
Was Nancy Grace involved in that case?
As far as covering it,
Yeah.
as far as covering, I'm sure she was. I mean, that's what I remember. Some of it. In the most recent one, it wasn't that long ago. She brought up there was a fairly new John Bonet, and I watched her show because she had I think John Ramsey on the show. Yeah. Pretty sure.
Yeah, I don't remember. That was very long ago, but there's a lot of similarities between that case and this one as well. Letting them contaminate the scene.
You have the Nancy. I mean the
John Benet Ramsey.
Yeah, John Benet Ramsey and Miss Woods, Yvonne Woods, Missy Woods, being the analyst. She started during those years, right? I'm just saying how you conceal from a state level, and I think she was with the state Colorado Bureau of Investigations at that time, and so just the fact of how they were handling DNA and the cases that she was involved in, how the John Bonet case has not come forward and said, look, where's the underlying data?
She did. Before we go, do you wanna have a look at that one? Quick. I want to keep you guys. It's like 3 minutes, and then give you a little teaser of what you can expect tomorrow. This is an old video. Okay, so let's just let's go to this. Are you okay with that, Big Amish? I'm going to play like 3 minutes.
Yeah, go ahead.
And then I'll send you the one that she did last night. Okay. Just put it back here on. Okay. All of you. Talking about cocktails, somebody take me to America. I also want to visit.
She looks tame there.
Okay.
I am convinced that people still care about the John Bonet Ramsey case because a child was brutally murdered. The scene was staged. And
same thing. You're right. Yeah.
Justice has never been obtained in that case. There was a 3-page ransom note and a practice note written within the house. Whoever the killer was not concerned they were going to be caught. When you look at the circumstances, they also don't make any sense. If someone was going to break into the home and leave a ransom note for an obscure amount of money, which coincidentally was John Ramsey's bonus that year, gee, who would have known that? And again, I do not think Mr. Ramsey killed his daughter. But to come in, to kidnap the girl, go through all the drama of leaving this ransom note, and then go, oh, you know what? Forget the money. I'm just going to kill her and leave her body in the basement. That's, I believe, has bothered people, gotten under their skin since it first happened. Another thing regarding John Bonet, I think it struck a chord because it touched on the whole child beauty queen mill, and that fascinated people. And also because of the child beauty queen pageant she had been in, there were a lot of pictures and video of her that you don't always have with child victims. So the public got to see her over and over and over again, and thereby, ergo, believe they knew her. They became familiar with her. They think they know John Bonet, and they therefore felt her loss even more deeply. I do not believe the John Bonet Ramsey case will ever be solved. I truly do not. I think the case was bungled at the get-go. When Patsy Ramsey opened the front door that day in the same clothes she had on the night before, in full hair and makeup, including eyeliner and mascara, at that moment, all family members should have been separated and questioned. At that moment,
Same like 1122.
and other evidence, forensic evidence, should have been preserved. That did not happen. There's no bad guy here. The police didn't intentionally bungle. It just happened that way. And I don't believe that case will ever, ever be solved. But I can tell you this. Burke Ramsey did not kill his sister.
What's up, guys? I'm Juliana Rancic, and you're watching the Live
Wow.
from the Red Carpet YouTube.
Yeah, there's so many similarities. You're right.
Too many.
Too many. And then
This is right, you guys. Why does she not have the same open-minded view in this case that she had then? That's a question.
And you pointed out last time, and you were right. The grand jury in that case did return an indictment for both for the parents for not for the murder, but for neglect of the child. So
yeah, there was a grand jury indictment. Was it for John and Patsy Ramsey or something?
Yes, both of them.
Also, there was also a parallel proceeding there. I actually saw something where a guy was talking. This was many years ago, so he talked about the tunnels in Colorado.
Whoa.
Mhm.
Okay.
I would have to revisit that, but that's another case. So you guys just remind us, because we sometimes go off onto a different subject completely, and you see how these things tie in with one another. Patsy. I said Patsy.
Yes. No, that's great. Yeah, we'll carry on that. But yeah, make sure you send me that link. That way I'll prepare for that. And
Okay. All right, guys. Thank you. Thank you so much, all of you, for being here. I really appreciate it. And then, if Big Amish is willing, we can meet again tomorrow.
Yep. Look forward to it. Thank you, Blue, Alicia, Lucy, Patty, everyone.
Lucy, Patsy.
Have a great day.
Have a wonderful day, guys.
And Bluebird.
See you. And Bluebird, yes. Lucy, Bluebird, Misleading Evidence, Linda.
And Linda. Yes.
All of you. If we missed you, it's not on purpose.
Love
Just
you all.
looking what's on the screen. Oh, Perfectly Broken. Jeff, how's it? You late. You missed
made
us. You made it. We'll see you tomorrow, Jeff. Thank you, guys. Have a wonderful day.
Yep. Bye-bye. Thank you again.
Bye-bye.